Hi, I'm Greg Dell here with attorney Rachel Alters, and we're going to talk about Lincoln Financial Group, which took over Liberty Mutual, actually, which was a very large disability insurance company. And now the combination of Lincoln Financial and Liberty became, I think, what would be probably, by cases they handle and the assets they have under management, would probably be one of the top 5 largest group disability insurance companies right now.
Yeah.
And I say group because it's 99.9% group disability employer provided policies that we see from Lincoln and Liberty over the years. Of course, there could be an individual, but this video is going to talk about how to handle an ERISA appeal. And in this video, we want to give some tips, some advice about how to handle an appeal, our experience in handling these appeals, why it's important to have a lawyer to help you handle these appeals, and the significance of your appeal and how that contributes to a lawsuit. So, person just got their denial letter watching this video. What are the first steps that have to be taken right now? Forget about contacting a lawyer, but to get the process going as if they had already hired us, what are we going to do to help them with their appeal?
Right. So as soon as we become aware that a claimant's been denied and we represent them, the first thing we do is obviously we request the claim file so that we can see what it was that the insurance company relied on when they denied the claim. And at some point, if the person was being paid for whether it's a year or 6 months or many years, there'll be a lot of documentation and medical records in the claim file that will be supportive of their disability. So we request that and we review it to see what they base that denial on so that we know exactly what to do and how to start our, start preparing the claim for the appeal and building up the case.
So these claim files, called the record,
Right.
later on, can be anywhere from 500 to 15, 20,000 pages long, depending
Right.
upon how long the claimant was on claim, how
Yeah.
extensive their medical records are. What are the most important pieces of information that you're digging in and looking for in order to set your strategy for how you want to file this appeal?
Well, we're looking to see what type of doctors the claimant has been treating with. So did they treat with doctors in the specialty of their disability? If they have a back issue, are they treating with an orthopedic doctor? If they have an issue with multiple sclerosis, are they treating with a neurologist, to make sure that they're treating with the proper physicians? Because the insurance carriers are looking for that, and they want to try and discredit the doctors that are treating the claimant. So we need to make sure that the treatment is proper, that they're having the proper tests, that the MRIs that are current and recent, CTs, any kind of evaluations that would show what objective proof the person has of their disability, that it's all in the claim file. And if it's not, that's the first thing that we do to tackle the claim.
So the first thing that you want to do when you do your appeals is look at the client's existing supportive medical documentation.
Right.
And if you don't find that it's significant enough, then what we usually do is recommend additional objective testing, whether it's MRI, CT, nerve conduction study tests, if we want a functional capacity evaluation,
Right.
blood work, any type of additional objective evidence, we'll go ahead and get that. But what is the important document that you want to see from the insurance company to determine how they reviewed the medical evaluation of the claimant?
Well, usually there's a peer review report, and in that peer review report, what it is it's from a doctor that's hired by the insurance carrier or works directly for the insurance carrier, and they've reviewed the medical records solely. They don't see the patient, they don't talk to the claimant. They just review the records and they make a determination based on their medical opinion whether the claimant is disabled. And 9 times out of 10, they're going to say that they're no longer disabled, that it's their opinion that the claimant's able to go back to their sedentary job, sitting at a desk 40 hours a week, or whatever the job may be. And they usually disagree with the treating physicians that the claimant's already seeing, saying that they don't have a reasonable basis or there's no objective proof of their disability, and they're perfectly fine to go back to work, which is usually not the case.
Now, what I see with Lincoln and Liberty is that no matter how much evidence you have initially from your treating doctors, that they're going to universally adopt the opinions of the reviewing doctor, regardless of what the treating physician said, and say,
Right.
well, the reviewing doctor who never saw you, never spoke to you, never probably spoke to your doctors, found that you shouldn't have restrictions and limitations.
Yep, that's usually the case.
And so that is why that's a big starting point. And now what we do is put a strategy in place and say, in light of what that doctor said, we work with your treating doctors to get to the point where we can prove that you are unable to do your job. But the biggest way that we do that is through, which is what is very unique to our firm, is the custom attending physician statements that we do. So talk
Right.
about those and why those are so important, and how a claimant who's never been involved with this type of thing would never even think to do those, let alone really know how to do those.
Right. Well, usually the attending physician statements are prepared by the insurance carrier, and they prepare them in such a way that pretty much tricks the physicians into answering questions in such a way that gets the claims denied. So it's a one-page form, and it asks for what the medical diagnosis is, and then they'll say, well, what kind of job is the claimant capable of doing? And they'll say, heavy duty, light duty, medium light, and then sedentary. And they often don't even put any kind of option for less than sedentary. And many of our claimants can't even do sedentary jobs because they have back pain, or
Right.
they have such conditions they can't sit for long periods of time. And the insurance carriers often don't even put that option on the form. So they trick these doctors, send them right to the doctors, get them to sign off, and that's how the claims get denied. We will tailor the forms so that we know exactly what the claimant's job description is that they are unable to do, specifically what the diagnosis is, what the restrictions and limitations are. We'll put them in the form and ask the doctors specific tailored questions so that they can answer them in detail, so that when we return them to the insurance carrier, there's a very clear picture of what the client's unable to do.
Right. And then we'll go not necessarily from one doctor, but it could be 2, 3, or 4 doctors
Sure.
that we get those from. And we get it to the point where no reasonable doctor could say, no, I disagree with those opinions. The other thing is that we know exactly what the Lincoln Financial and Liberty claims people are trained to look for. So now we put them in this position to say, wait a second, you've presented us with all the evidence to prove that the person's disabled. So if they were to deny it again, a judge looks at it and goes, what else did you want this person to do other
Right.
than possibly cut their arm off, cut their leg off, or be in a coma?
Right.
So it gets to that point where you want to put a really, really strong appeal in, because then you have your best chance to go at court, and that helps you to negotiate the best settlement or win down the road, obviously. So that is essential. The other thing people have to realize is, if you do your own appeal and you don't do a great job, and then you want to hire a law firm like ours, you can do that, but we're married to the appeal that you did. We can't add anything new.
Right, you're doing the insurance company a favor if you don't hire an attorney. That's what they want you not to hire a lawyer. They want you to send in a one-page letter saying, I appeal this,
Right.
I disagree, and send in no other medical evidence, because that's their best chance of having to pay you very little when it comes to a settlement.
Right. So here's the steps to take if you're sitting there with this denial letter. You can submit a free consultation on our website, and it will come to any of the lawyers here at our firm, and we'll call you right away. You can give us a call now to discuss your claim. A lawyer will take your call immediately. The one thing we're going to need from you is we're going to ask you to email us a copy of your denial letter, because that's going to give us a lot of information initially, enough to know if we think that you have a claim that is something that we can help you with. And then from there, we'll dive into getting everything else should you decide to hire us. Very important for you to know that we don't charge any fees or costs unless we make a recovery for you, which means there's no risk in hiring us whatsoever, because you're never going to owe us any money unless we get you money. So that makes that fee process very easy. The other thing that you should know is we are a nationwide disability firm with more than 10 disability insurance lawyers, and we have the resources and the ability to represent you in any court in the entire country. And you're never going to have to leave your home for us to help you. So that is super convenient for you as well. So we look forward to reviewing your claim. We thank you for considering us, and hopefully we'll be talking with you shortly.
Thank you.